Welcome to 4 Slide HR, and in this today's session we will discuss on the new labor code which has been passed by the government of India from both the sessions and both the parliaments, their houses, Lok Sabha and Rajya Sabha, and which are ready for implementation from May 1st, 2021. But there is a recent news that it may be postponed for implementation for some time due to some territorial elections. So in this today's session, we are going to learn about the 4 code related to the labor code and labor relation and labor scenario is going to change in India. What is their impact and the benefit and versus for the employee, laborer as well as the principals and the employer. So in this we will cover all 4 labor laws and labor code: the code on wage, code on industry relation, code on social security and code on organization safety and health. So first of all, we are going to cover the code on wages 2019. The code of wage 2019 is the combination and consistence of the 4 laws earlier act related to the wages, which decided wages in the different level in the context of Indian industry. There was 4 different laws which are based and related to the wages, and that has been combined or merged in this one act, the Code on Wages 2019. That is the Minimum Wage Act 1948, Payment of Wage Act 1936, Equal Remuneration Act 1976 and Payment of Bonus Act 1965. These 4 different law which determine the wages for a employee or a laborer or a worker in our industry has been merged in one code. The code is known as Code on Wage 2019. Now understand what has been changed in the meaning and the processes of these laws, which we have to understand for effective implementation of these codes in the industry, when it will come in the existence from the May 2021. All workers are employees, but all employees not worker. The definition has been changed as per the Code on Wage 2019. It says that all workers are employee. They come under the category of employee, but all the employees are not workers. It means that they have distinguished the blue collar and the white collar according to their work profession, their physically work efficiency and the time put it on their activities as a worker, as an employee. All employees now covered under the wage code. This is the change point here. In all the employees now covered under the wage code, even that are the managers and supervisors, are covered under the minimum wage and payment of wage provision now. This is an important change which has been made in this Code of Wage 2019, that all employees who are in the organization enrolled or not enrolled, direct or indirect role, they all are come under the category of wage code as employee, manager and supervisor are covered under the minimum wage and payment of the wages provisions. Then the contractor, permanent employee who is employed for an activity of his establishment, if deputed to work in another establishment, may no longer be the contractor labor. Means if they are on contract but they are working for the another establishment, they will not consider as the contractor labor, but they will be considered, we will have a long discussion on this particular topic in later. So now come to the minimum wages for all. What is that? First, understand that no more scheduled employment provision would apply to all. This is the one point which we have to understand, that no more scheduled employment provisions would apply to all. Then the central government to fix a floor wage across India, it will be equal, which will be fixed by the central government, that wage is the equal to all, that is known as floor wage, but the state has given a right in this code on wage to fix the minimum wage according to their situation, paying capacity and the worker level or the hardship and skills. Concept of the scheduled employment doesn't done away with wages to be fixed on skill and geography. So there is the existing scheduled employment has been vanished away, done away, with the wage to be fixed on the two parameters. The two parameters are the skill and the geography. Geography is considered because there is the nature, the living standard and the arrangement of the livelihood are different. So that's why the geographical and the skill based wage has been, wage determination term has been fixed here. Now come to the bonus. Additional disqualification of the employee for receiving bonus is added, that an employee who is convicted, specifically not dismissal, convicted, if he is working and he has been convicted for any case, most important, the sexual harassment, an employee who has caused sabotages to any property of the establishment, and he is convicting to find the convicted in that case of sabotage of the property of establishment, then he will be disqualified for receiving the bonus for that particular financial year or bonus period. The bonus shall have to be paid by transferring the amount to the bank account of the employees. This has been made a restriction to the, especially the contractor, but usually they collect the bonuses from the principal employer and keep that with them, did not pay to the worker or the employee. So it has been conditioned in the Code on Wage 2019 that the bonuses must be transferred to the bank account of the employee. Then we will have a comparison between the two existing and the law and the term and the facility with the existing law and coming to the code on wages. What are the changes actually has been made? The concept of gross wage, like air freight case, has been changed. There was early in the existing act, it was there, and then the applicability of the provisions limited to the wage threshold. Earlier it was existing in the previous laws. Then employer definition limited to direct employment. Then minimum wage only to scheduled employments. Then date of payment of wage differ on the number of employee employed in an organization. These are the existing terms of the laws related to the wages. And what has been changes in the Code on Wage 2019, no longer hold goods. New wage definition: if the aggregate of excluded allowances exceed 50% of the excluded allowance to be included in the wage, means if there is any allowances or the goods, or if the aggregate of excluded allowances exceed 50% of the excluded allowances to be included in the wage, then the applicability and applicable to all employee irrespective of the wage threshold. It will be applicable to all employee throughout the organization. No irrespective of the wage threshold. Earlier it was there. Then contractor is also a employer now. Contractor is also a employer now. In the previous laws, the principal employer were definitely the ultimate responsible for any mishap in the organizer related to the contractor work. But now this new wage on code has made the contractor responsible as the employer. Then the scheduled employment done away, and wage to be paid on or before 7th after the wage period, irrespective of the number of employee and employees. Now there is a one change. Earlier there was, if in your organization there is a strength of less than 1,000, you have to pay your wages to the worker, to the employee on 7, and there is more than 1,000 employee, you can pay their paid after 10th of the consequent month. So now it has been fixed for a single date to all the irrespective of any number of the employee in the organization, the 7th of every month for the consecutive month. Then the Amalgam 3 Act versus then come to the Industrial Relation Code 2020. In the Industrial Relation Code 2020, that has been 3 acts has been merged in one, the Industrial Relation Code 2020. What are those acts? We are going to discuss in this session here. That Amalgam 3 Act versus the Industrial Dispute Act 1946, the Trade Union Act 1926, then Industrial Employment Standing Order Act 1947 or something, and industry definition has been changed in this new Industrial Relation Code 2020. That the definition of the industry under Industrial Relation Code has totally changed. It excludes the charitable society, philanthropic services and domestic services exclude from the definition of the industries. Then fixed term employment. Related to fixed term employment, there has been many changes made in this Industrial Relation Code 2020. What are those? That is allow hiring worker on fixed term contract. Now it has been legalized that you can hire and promote the fixed term contract for 6 months, 1 year, 2 years, and it exactly we will be discussed in the later on in this session. That eligibility for the benefit like that of a permanent worker also has been changed. Then gratuity payable on the pro rata basis has been changed. No retrenchment compensation payable on termination of fixed term employment. It is a basis all the time. If there is a fixed term employment, it is already a sense that he have to go out from the organization when they at the fixed term employment available. So there is no compensation, and it has been included strictly in this Industrial Relation Code 2021. Then the applicability applies to the workers only. Worker definition akin to present workman definition. However, for the purpose of trade union worker means all the person employed. Now the trade union purpose all the person employed in the organization, and applicability for the workmen only. All workers are employees, but all employees are not workers. Remember this definition. Mandates setting up on grievance redressal committees to dispute arising out of the individual worker grievance to be heard by the GRC, Grievance Redressal Committee, Section 4/1. Aggrieved worker may file application before Grievance Redressal Committee within 1 year from the date of cause of action. If something happens, the person who feels that they have been harassed or something happened, they can file their complaint to the grievance redressal committee within 1 year of the incidents happen. Grievance redressal committee to complete its proceeding within 30 days of receipt of the application. Within 30 days of the receipt of the application, aggrieved worker may file appeal. 60 days limitation for filing appeal. He is free or he is respected bid against the conclusion or the committee outcome and committee what they have finding and what they have given the result from this inquiry or proceeding. The applicant have aggrieved employee have the right to file a complaint limit and the appealing within 60 days of the outcome of the proceeding has been given by the grievance redressal committees. The worker may make application to the industrial tribunal after 45 days of making application to conciliation officer. Such application to be made within 19 days. In this new industrial relation code, the days and the responsibilities has been fixed, specifically the time limit when you have to apply, when it should be resolved, and this is the one important part of this industrial relation code 2020 which has been incorporated in this new code. Then references system removed, whether worker can directly approach industrial tribunal on the failure of conciliation. If there is a conciliation is fail, then the worker can directly approach to the industrial tribunal for their issues and grievance. Then the industrial tribunal replace labor court and consists of 2 members, one judicial and the other administrative. The industrial tribunal will be there who will be replaced as per this industrial relation code 2020 replaces the labor courts and consists of 2 members. One is the judicial and the administrative. Threshold limit for permission for layoff, retrenchment and closure enhanced to 3,000. If there is 300 people in your organization, if you have to lay off, retrench and closure, then the threshold limit means 3,000 is that you have to get approval for the layoff, retrenchment and closure for if the number is 300 now. 1 year after retrenchment of worker, vacancy can be filled by any other person. Means you will not be bound to reinforce these retrenched worker after 1 year. You can fill the vacancies with other person. Workers reskilling fund set up for training of retrenched worker through contribution of the employer of amount equal to 15 days wages last drawn by the worker immediately before the retrenchment. So here is the one important point which has been included in the Industrial Relation Code 2020, that is the worker reskilling fund set up for training of retrenched worker through the contribution of the employer of an amount equal to the 15 days wages last drawn by the worker immediately before the retrenchment. Then in case of the trade union, but the scenario has been changed in this new industrial relation code, which we should understand properly. The registration of the trade union, at least 7 members should apply. Trade union will register only if they have 10% membership or 100, whichever is less. 10% or 100, whichever is less. Means if you have to register a trade union, there should be 7 members. 7 members can apply, the majority and the team, and the number of people minimum should be not less than 7 to apply for a registration of a trade union. If there is only one trade union of worker, then the employer shall recognize the same as sole negotiating union. If there is an organization, one trade unions, that is the sole negotiating union for the employer. If there are more than one registered union of workers, the trade union with support of at least 51% will be recognized as sole negotiation union. Mean if there is 3 unions, then their 1.5 unions will be recognized as the sole for the negotiation bodies. Then, if no trade union have 51% or more, then negotiating council should be constituted. Then the council, purpose of the provision of council is there, is the negotiating council should be constituted. Negotiating council must have the support of not less than 20% of the workers. Each negotiation council shall have one representative. Minister cannot be officer bearer of any trade union. It is also conditioned that if any trade union there is a ministering who has holding the post of minister anywhere, he could not be the office bearer of any trade union. Now come to the preview of the strikes and lockdowns. But the new industrial code said about the strikes and lockdown, prohibit strikes and lockdown in all industrial establishment. First condition is there will be no strikes which are not striked by the laws and this industrial law and lockout for industrial establishment without giving 14 days notice, where notice is valid for 16 days. That has to understand during pendency of the cancellation proceeding before a cancellation officer, during pendency of the proceeding before the tribunal, and the during pendency of attribution or settlement, or while on operation is in operation. So that is the condition for giving a notice of 14 days, where notice is valid for 60 days only. Then come to the standing orders. Threshold of 300 or more workers for an industrial establishment to obtain certification of standing orders if the standing order differ from the model standing order made by the central government. There is the threshold has been increased for 300 from the 100 people. If there was earlier 100 people in the organization, they have to go for the standard standing order, and which has to be authorized and approved by the government of the state authorities. But it has been increased for the 300 and below the worker is there, then the threshold of the minimum number will be 300. Mean you can apply the model standing order over the central government. If an employer adopt model standing order of the central government with respect to the matters relevant to the employer's industrial establishment, then the model standing order shall be deemed to be certified. But it said, if the employer adopt the model standing order of the central government with respect to the matter relevant to the employer's industrial establishment, but the industrial establishment, their condition and the circumstances they have, then the model standing order shall be deemed to be certified. Next point, the standing order provision is applicable to both factory and non-factory establishment. Now, like the ITs, BPOs, hotels, shop and malls, it will be included to all now as per the new provisions of the Industrial Relation Code 2020. Domestic inquiry, disciplinary inquiry shall be completed ordinary within 90 days from the date of suspension of worker. So it is mandatory here now that you have to complete the disciplinary inquiry, the domestic inquiry within 90 days from the date of suspension of the worker. Worker entitled to 50% of wage for the first 90 days and 75% thereafter. If you have dismissed a suspended employee or a worker, they will be entitled with the 50% of wages for the first 90 days and 75% thereafter if the suspension go for after the 90 days. This is about the Industrial Code 2020. Now come to the next code on the industrial or the labor code, that is the Social Security Code 2020. Whatever the changes has been made in this new code, which are going to be implemented throughout the industries and establishment pan India, and that has been related to the social security. The important changes and implementation has been introduced in this new wage code of the Social Security Code 2020. Previously there is the 10 of the laws and the act related to the social security has been amalgamated or merged with this one Social Security Code 2020. What are those? These are the Employee Compensation Act 1923 Chapter 7, the Employee State Insurance Act 1948 in the Chapter 8 of this new security code added, and the Employee Provident Fund and the Miscellaneous Provisions Act 1952 in the Chapter 3, and the Employment Exchange Compulsory Notification of Vacancies Act 1959 in the Chapter 8, the Maternity Benefit Act 1961 in the Chapter 6, then the Payment of Gratuity Act 1972 in the Chapter 5, and the Sine Worker Welfare Fund Act 1981, the Building and Other Construction Worker Cess Act 1996 Chapter 8, and the Unorganized Workers Social Security Act 2008 Chapter 9. So these are the previous existing act has been merged in this Social Security Code. They have been added some compulsory part in this code as on the center level. Then there will be rule defined for the center level, and the state has been some right for their state. Otherwise, it has the center embodied act and the code. It will be implemented in same position throughout the industrial establishments. So now in this code, extended social security to all employees and workers either in the organized or unorganized or any other sectors. Introduce various new expressions such as the career center, aggregator, 7th schedule, gig worker, platform worker, and wage ceiling has been added in this security code 2020. So you must remember here there is a new expression added like the career center, aggregator, 7th schedule, then the gig worker who are the solo worker, and then the platform worker and the wage ceiling. Provide for registration electronically or otherwise of every establishment. The mostly if you have to register for the Social Security Code, you have to go to the electronic mode only. For every establishment it has been made mandatory. Aggregator means a digital intermediary or a marketplace for a buying or user of a service to connect with the seller or the service provider. So there will be a digital aggregator who will be link between the authority and the establishment for applying such of the registration. Then the gig worker means a person who perform work or participate in a work arrangement and earns from such activity outside a traditional employer-employee relationship that has been named and expression given as the gig worker. There is no traditional employee-employer relationship or agreement. Then it comes to the platform work, means a work arrangement outside a traditional employee-employer relationship. That is also the one term and has to understand deeply in which organization or individuals use an online platform to access other organization or individual to solve specific problem or to provide specific services or say any such other activities which may be noticed or notified by the central government in exchange for payment. Means when some worker of one establishment went to the other establishments do some sort of work that is expressed and included in this new social security code as the platform work, and the person and the establishment have to cover such type of workers and work people in the social security. Then what is happening with the EPFO scheme with this new social security code? So we have to understand that also, although the EPFO is the central body or managing a huge fund of the social security contribution of the employee and employer in favor of the employee, the EPFO scheme is applicable to establishment employing 20 or more person, a limitation period of 5 years for initiation of 2 years for concluding inquiries introduced, and then employing 20 and more person as the limitation for the 25 years of period. Otherwise it will be on every establishment. Then penalty for the cases happen under the PF has been increased for 10,000 to 1 lakh rupees, and imprisonment of 1 to 3 years on deduction of employee contribution from salary and non-depositing. Means if you deposit the EPF contribution from the employee salary but not deposit it to the EPFO, then the penalty will be charged from you, from the employer, 1 lakh rupees, and the imprisonment will be 3 years instead of the penalty of 1 lakh rupees. Otherwise both, it will be depend on the case. Then subsequent failure to pay contribution attract imprisonment of 2 to 5 years and fine of 3 lakhs. If the failure is subsequent continued, then the contribution attract the imprisonment of 2 to 5 years and fine of 3 lakhs rupees. Now the ESI schemes, what it has been happens, applies to establishment employing 10 or more person. Government can extend ESIC scheme to any hazard occupation also, even if a single employee is employed. If there is a hazard occupation applicable and one single employee is working in that organization, the ESIC scheme, mean employee state insurance scheme, will be applicable for that employment. If any employer failed to pay ESIC contribution, even then ESIC has to pass on the benefit to the employee, which ESIC can recover it from the employer to the extent of the capitalized value of the benefit, net of any payment of contribution among interest and damages payable to the employer. So this has been strictly introduced in the Social Security Code 2022. Then come to the next pages. The central government shall formulate and modify from time to time suitable welfare scheme for unorganized worker on matter relating to the life and disability cover, in that then health and maternity benefit, old age protection, education and other benefits as may be determined by the central government, will formulate and notify the rules on time to time as per the suitability and the requirement of welfare for the unorganized worker and the worker who working in the unorganized sector. Then the state government shall formulate and notify from time to time suitable welfare scheme for unorganized sector, including scheme related to the provident fund, employment injury benefit, housing, educational scheme for children, skill upgradation of the worker, and funeral assistant and old age homes. So it has been bifurcated in two portions where the central government can formulate and notify the schemes for unorganized sector workers some extent, and the other extent by the state government. Then there is no changes in the applicability of the provisions of gratuity, maternity benefit and employee compensation under this Social Security Act and Social Security Code. This is all about in the mandatory changes in this Social Security Act. Let's come forth with the Occupational Safety, Health and Conditions of Services Code 2020. In this Occupational Safety, Health and Conditions of Service Code 2020, near about 12 and 13, the mandatory acts and law of its existing has been merged with this Occupational Safety, Health and Condition of Services Code 2020. This is the combination of the Factory Act 1948, the Plantation Labor Act 1951, the Mine Act 1952, the Worker, Journalist and Other Newspaper Employment Condition of Services and Miscellaneous Provisions Act 1955. The Working Journalists Fixation of Rate of Wages Act 1958, the Motor Transport Workers Act 1961, the Beedi and Cigar Workers Condition of Employment Act 1966, the Contract Labor Regulation and Abolition Act 1970, the Sale Promotion Employees Condition of Services Act 1976, the Interstate Migrant Worker Regulation of Employment and Condition of Services Act 1970, the Dog Worker Safety, Health and Welfare Act 1986, the Cine Worker and Cinema Theatre Worker 1981, the Building and Other Construction Workers BOCW Regulation and Employment and Condition of Service Act 1996 has been included in this Occupational Health, Safety and Condition of Service Code 2021. What are the changes and the authority has given by the central government in this code to the state government and the legislative governments? State government shall be appropriate government in respect of the occupational safety, health and working condition in a factory situation in the state. It is mentioned in the section 2D of this code, means all the authoritative power has been given to the state government in the Occupational Safety, Health and the Work Condition Code 2020. Issuing of appointment letter mandatory by the employer of an establishment included existing establishment within 3 months of the commencement of the code to promote formalization of employment. Section 6(1) of the section subsection F. It means it is mandatory now to, in this code, every person or every employee should have the appointment letter in their organization where they have employed. Then free of cost annual health checkup for employee above the specific age by which it would be possible to detect diseases at any early stages. So it is mandatory that a free of cost annual check has been given and provided by the establishment to their employees. Engagement of contract labor in core activity is prohibited. Code defined what is core activities. We will discuss it later in. On one registration under the code of establishment having 10 or more employees, then the factories with 10 or more workers registered in accessory as an establishment. However, all the provisions of the code are not applicable as per the section 2, 5th and the 3rd of this code. For factories with 20 workers with power and factory worker without power, all provisions of the code are applicable, including registration. No worker shall be required to allowed to work in any establishment or class of establishment for more than 8 hours in a day. Every worker employed in an establishment shall be entitled to leave in a calendar year with wage, subject to the condition that he has worked 180 days or more in such establishment more than 240 days. Now it has been fixed for the 180 days. Here it needs to be clear that they have to work physically and the present physically in the work days. Worker will be able to get more leave carryover restricted to the 30 days, but provision made for encashment of leave in excess of 30 days has been now. No lapse of leave can be encashed every year. If there is a lapse of leave encashment can be encashed every year. Means the earlier there are the provision of the leaves of the leaf live SL and CL that will be encased for every year. Now the code enable employment of women in all establishments for all types of work, included work at night beyond 7 p.m. and before 6 a.m. subject to the condition relating to the safety, holiday, working hours, and their consent is required. So now the female worker and can work in the organization with the night shift to beyond 7 p.m. before 6 a.m. condition, also based on some conditions. Then the contract labor provision relating to the contract labor will apply to establishment employing 50 or more contract workers and to every manpower supply contractor employing more than 50 workmen. Section 45 contractor engaging contract worker in more than one state can obtain a common license from the designated authority. There is the provision of the common license from the designated authority if a contractor is working in the multi-states. Welfare facility for the contract labor to be provided by the principal employer. It is same as earlier it was mentioned in the Factories Act or the Contract Act. Interstate migrant worker. The interstate migrant worker means a person who is employed in an establishment and who has been recruited directly by the employer or indirectly through contractor in one state for employment in such establishment situated in another state, or the subsection 2 has come to his own from one state and obtained employment in establishment of another state, hereafter called destination state, or has subsequently changed the establishment within the destination state under an agreement or other arrangement for such employment and draws wages not exceeded the amount of rupees 18,000 per month. Provisions of interstate migrant workers applicable to the establishment which 10 or more migrant workers are employed or were employed on a day of the preceding 12 months, and medical checkup facilities, ESIC's PF benefit are to be provided in interstate workmen too. But one thing which have to remember here, that is their wage ceiling amount, who will be considered as interstate migrant worker whose wage drawn is not exceeded than the rupees 18,000 per month. And in case of a public emergency or disaster or pandemic in whole of India or part thereof, the appropriate government may by notification exempt any workplace or work activity or class therefore from all of any of the provision of this code for such period and subject to such condition as it may think fit. Then the wages mean all remuneration, whether by way of salary, allowances and otherwise expressed in term of money or capable of being so expressed, which would, if the term of employment expressed or implied were fulfilled, be payable to a person employed in respect of his employment or a work done in such employment, and included basic pay, dearness allowances and retaining allowances. It is as existing, but there is the changes. The basic pay has been changed. We will discuss that in later on in detail, but it does not include any bonus payable under any law for the time being in force, which does not form part of the remuneration payable under the terms of employment. Then the second part of the not included the value of any house accommodation or of the supply of light, water, medical attendance or other amenities, or of any services excluded from the computation of the wages by a wage means all remuneration, whether by wage of salary, allowance and otherwise expressed in the term of money and capable of being so expressed. That has been included the three parts: basic pay, dearness allowance and retaining allowance if any, but does not include any bonuses payable under any law, and then the value of accommodation of housing and additional facilities provided by the employer. Now, then go to another part. The contribution paid by the employer to any pension or provident fund will also not included in the wage. Any conveyance allowance of the value of any traveling concession will also not include, and any sum paid to the employed person to defray special expenses entailed on him by the nature of his employment, mean any expenses for the traveling and work done for the establishment. House rent allowances will not as the part of the wage. And then remuneration payable under any award or settlement between the parties and order of court or tribunal, that will not included the wages. Any overtime allowances, any commission payable to the employee, any guarantee payable on the termination of employment, and any retrenchment compensation or other retirement benefit payable to the employee, or any ex gratia payment made to him on the termination of the employment, that does not include in the wages as per this new wage on code in the labor code. Then provided that for calculating the wage under this clause, if payment made by the employer to the employee under clause A to 1 exceed 1/2 or such other percent as may be notified by the central government of the all remuneration calculated under this clause, the amount which exceeds such 1/2 or the percent so notified shall be deemed as remuneration. Welcome to 4-Slide HR, and in this series of the labor code announced by the central government of India, and in this third phase of this code where we are learning about the 4 different codes related to the labor codes of 2020. And in this we have covered the wage code, and then we have covered the labor code, and we have covered here the code on wage, the code on industry relation, the code on social security, and the code on organization safety and health. Now we are covering the definitions under this code, as we have already understood that these are the codes, their basic fundamental, their added and deleted some new concept in these codes. Now we will share with you the definition, what changes had been done in this new code of labor. The definition of wage under the code, under the labor code, is according. First, we are going to discuss about the wages. What are the wages? Wages mean all remuneration, whether by way of salary, allowances, or otherwise, expressed in the term of money or capable of being so expressed with mean which would, if the terms of employment expressed or implied were fulfilled, be payable to a person employed in the respect of his employment or work done in such employment, and includes, there is the 3 parts of the wages which has been defined in this new labor code, that are the basic pay, dearness allowances, and the retaining allowances. Always this segmentation of the 3 parts, if we go as a whole definition of the wages or salary, there are the 3 parts. One is your basic pay, then is your allowances, and then is your retaining allowances, mean the retirement allowances, etc. So now what does not include in this? In the new definition, with the new definition, there has been some portion excluded from the wages. Any bonus payable under any law for the time being in force, which does not form part of the remuneration payable under the term of employment. And second, the value of any house accommodation. If the employer, the organization is providing you any house, so the value of that accommodation, of the supply of light, water, medical attendance, or other amenity, and services excluded from the computation of wages by a general or social order by the appropriate government does not included in the term of wage. Then any contribution paid by the employer to any pension or provident fund and the interest which may be accrued thereon, that is also excluded. Any convenience or conveyance allowance or the value of any traveling concession, any sum paid to the employee person to defray special expenses entailed on him by the nature of his employment, house rent, that is also the not part of the wages here. Remuneration payable under any award or settlement between the parties or order of the court or tribunal, and any overtime allowances, any commission payable to the employee, and gratuity payable on the termination of employment, and any retrenchment compensation or other retirement benefit payable to the employee, or any ex gratia payable made to him on the termination of employment not included in the definition of wage. The new definition of the wage is only the basic pay, dearness allowances. Basic pay means the base based on your skill, the basic amount given for the work you have given on, you are doing, you will do according to your skill, ability and knowledge. Then dearness allowances to compensate with the basic essential requirement you have to fulfill, that allowances you have given as the dearness allowances. And then retaining allowances, pay you will be retained for that the allowances has been given, that is come under the new definition of the wages. So many of item I have mentioned here that has been excluded, like house rent allowance is not the part of wage. Understand that one important thing. Overtime was not earlier also the part of the wages. Then commission etc., that is not. Gratuity, that was also not. Then any specific expenses entailed on the any employee in the nature of his employment, that is the reversal part, and that is not also the part of remuneration or the wages. Or contribution you have paid. Here this one thing is you have to understand that the contribution paid by the employer for any pension like ESI and EPF, that is not the part of wage, that are the excluded as the retirement benefit and the social security, because the separate laws has been performed and introduced for the social security. Next, we are going to add, this is provided that calculating the wage under this clause, if a payment made by the employer to the employee under clause A to 1 exceeded one half or such other percent as may be notified by the central government of the all remuneration calculated under this clause, the amount which exceeds such one half or the percent of so notified shall be deemed as a remuneration and shall be accordingly added in wage under this clause. If anything which come to the one half mean 50%. One half mean 50% of anything that will be deemed as remuneration and shall be accordingly added in wage under this clause. Then the further that for the purpose of equal wages to all gender, for the purpose of payment of wage, the emulation specified in clause D, F, G and H shall be taken to computation of wages. We will be explain that in later when we will go in one by one reading of all and presenting all the codes to you. Then explanation what come under this definition related to the wage under the labor code, where an employee is given a lieu of the whole or part of the wage payable to him any remuneration in kind by his employer. The value of such a remuneration is a kind which does not exceed 15% of the total wages payable to him shall be deemed to part form part of the wages such employee. So it means finally the conclusion is that the total wage paid to him, the 50% of that minimum is come under the wage definition. There the basic pay, dearness allowances, and the your third one was the allowances for the retaining allowances. Then, as per the first provision, exclusion state in clause A to 1 cannot exceed 50% of the total remuneration. This implies wages cannot be less than 50% of total remuneration. Whatever you are giving and providing to an employee, your wage should be 50% of that. It has been defined in the new definition of wage under the labor code. So finally, what will be the salary and the wage come to in account? That is your basic salary plus dearness allowances should be minimum 50% of your CTC, which is called as the cost to company for occurring or own an employee. Generally, dearness allowances and retaining allowances is not paid separately as part of salary. This implies that basic salary should be minimum of 50% of CTC. Why it come to the 50% of CTC? Because when the definition has given the three parts, the basic salary, dearness allowances, and then the retaining allowances, because the dearness allowances and the retaining allowances is not provided as the separately to an employee. So that's why it come to the 50% of whole remuneration you are providing to an employee in your organization. Now then come to the next impression is that if we go to the previous provision, exclusion state in the clause A to 1 cannot exceed 50% of total remuneration. This implies wages cannot be less than 50% of that thing or 50% of CTC. Then basic salary should be minimum of 50%. It has been mentioned in the previous slide 2. So this is for the emphasis and explanation which you have to understand according to the new labor code and which are going to implement it from the May itself, even though the date is not finalized as for some territory election is happening, but it is sure it will be implemented soon. So that's why you have to prepare yourself, your organization, you have to assess your ability to implement these codes as soon as possibly, because your basic pay will become 50% of your CTC, which has been mentioned as per the definition. Then we have to understand here what is the importance come out from this definition of the wage under the labor code, new labor code. If payment made under clause A to 1 except tribunal award amount exceed 1/2 or such that percent shall be deemed a remuneration and shall be accordingly added in wages for statutory compliance under the provision of the code. If you are going under the compliances of the statutory compliances under this new code or the labor code, what you have to do in this case, all if there any case tribunal they awarded some amount exceeds 1/2 or such that percent shall be deemed as remuneration shall be accordingly added in the wage for a statutory compliance purpose. The wage means the basic wage should be more than 50% of the gross wage. Thereby, the employer may fix at least 51% as basic wage plus DA, at the rest 49% can be fixed other component as enumerated in the exclusion clause of wages definition. Thus, bifurcation of the minimum wages should not be done because of the new definition of wage. Now, understand this thing, what is importance here. The first part we can consider later on, but the basic thing is that the basic wage should be more than 15% of the gross wage. If you are deciding a basic gross wage, actually there will the gross wage which you paid monthly basis, then are the other allowances which you pay on the quarterly basis, then on the annual basis. So those are the amounted, I have to exclude it from that. Then the gross wage come to you, the 51% of that amount you have to decide as the basic wage of an employee, and 49% have to given to the other components. The definition of wage will impose additional financial liability on the employer on the following payment contributions. To understand here, where the definition of the new wage impose the additional financial liabilities on the employer, there will be little bit impact on the employer when they pay out the payment and contribution. First is the quantum of overtime wages payable under increase. The quantity, the amount will be increased when there is the overtime concept available in the organization, as it is guided by the law. So you have to give overtime to a person he is working more than his schedule and stipulated time. Then quantum of bonus payable may also increase the case of those employees to whom the provision with regard to payment of bonus as contained the Wage Code Act 2019 would apply. The amount of gratuity payable will also be more, as the definition of the wage is the same for all the four codes, because the definition of the wage has been revised accordingly in all the cases which you are paying basis on the contribution and the payment based on calculating on the basic pay that will be increased. It is a little incurring of imposing some additional financial liability to the employer. Now, the employer contribution to the provident fund also be increased. ESIC's contribution would come down, but coverage will increase. What will be happen here? The ESIC contribution will be come down here. That is the important part. We will be understand this later on how it will be come down, and then we have to think of it. In the case of retrenchment of workmen, retrenchment compensation would also be enhanced because the basic pay has been increased. So here we are going to understand the minimum wage concept, how it will be implies, and minimum wage as notified by the government will be the floor wage earlier and now. If you go to there are basic wage, dearness allowances and the total wage. Earlier, if the people divided, the maximum organization divided their pays in the basic wage and then the dearness, because of the contribution and every calculation done of the basic wage. So now it has been finished that it will become under the whole. If you fixed amount, you divided that in the basic wage plus dearness allowances, then it will become the whole amount. But one thing you have to remember here, that is the minimum wage cannot be bifurcated, that will be fixed as basic wage. Now the provident fund under the new code, what will happen with the provident fund? And we should learn, we should understand that here the particular and the scenario one, we have divided it in the 4 scenarios for international workers. So what you have to understand it on the purpose of organization and perspective of organization. When we talk about the salary and the dearness allowances, for example in scenario 1, that is 8,000, then you are paying the house rented 4,000 rupees, total wage is 12,000, and your PF contribution as capped at 15,000 would be 960 rupees. 960 rupees. Code on Social Security 440 rupees as minimum wage can't be split. Minimum wage can't be split, so it would be 440 rupees now. And then Earlier it was on the basic wage, but now it will be all overall. Then it will be implies on all that it will be 1414. If go to the scenario level 2, if there is a basic wage is 12,000, then HR you are paying 4,000, conveyance you are paying 2,000, then washing 2,000, total salary will be 20,000 rupees. And in this scenario, what is going to happen? That is what the PF contribution will be decreased as earlier. If the basic is 12,000 rupees, then your payout contribution for the EPF it will be 14,440. Scenario third, then there is the 12,000 basic, 6,000 rupees house rent, and then conveyance, washing, total salary is 24,000, and your PF contribution will be down now. If there is an international worker whose basic salary is 3 lakh rupees, 150 lakh rupees, and 150 in total is 6 lakh, then the previous contribution was 54,000 rupees, but now it will be 36%. So there is, in perspective of the employer, if there is the lower paid manpower, then their amount and their financial impact will be increased. If the highest paid manpower is there, then it will be go down. So here is both sided, but it will be depend for your organization on what level of your salary is there and on the different levels. Now the gratuity, what is the definition and scenario of gratuity under this Social Security Code? If we talk about the gratuity in the previous, gratuity under the Payment of Gratuity Act and the Social Security Code, we have made a comparison over here. The basic NDA, there is the total of the salary is 28,000, because the gratuity for 10-year calculation base it will be 72,115 rupees only. But now in the new scenario, when the basic wage will be 50,000 rupees or 50% of the total CTC or gross salary, then it will be increased by the 2,011 rupees as per the new code. Then go to the retrenchment and closure compensation under new industry relation. If you are going to retrenching any employee, as per the Compensation Act under ID Act in 1947 and compensation under the Industrial Relation Code 2020. So here is also the compensation will be decreased. Here also 10-year compensation will be decreased, because it earlier was given on the full wage and then it will be decreased as 71,000. Here is some portion and impactful, not so much impactful for the employer perspective, but it will be loose for the employee who are going to be restrained, closure compensation and in the industrialization. Now overtime perspective, what will be happen in the overtime in this scenario now? So earlier you are giving the overtime on the basic under the Factories Act and the under Organization, Occupational Safety and Health. So there will be the basic counted as the 50% of your total wage. So understand this, the impact on the overtime will be applies on the employees, it will be cost for them. The next one is the offenses and penalties which will be penalized on the employer. In the first instance, fine of Rs 50,000 to 1 lakh rupees, 10 lakh rupees compoundable, understand this thing. Then subsequent commissions, then fine of 3 lakh to 20 lakh rupees or imprisonment up to 3 years non-compoundable. For employee and employees labor code and the advantage. First we are going to discuss about the advantage of these labor codes in perspective of employer and employees. If you go for the perspective of the employer, the reduction in cost of compliance, the compliance cost has been reduced, then elimination of high cost of claim to beneficiary has been reduced. I mean, if you are retrenching someone and there is some cases happen, so the elimination of high cost of the claims to beneficiaries, then provision of one registration license and on return, means if you are in the multiple state, you can get a centralized code and you can work upon the send or the registration and license or returns over there. Then web-based electronic labor inspection is their preferred, and no physically you the driver and paying something to these inspectors, that will be done. Then before prosecution opportunity to be given to the employer to comply with the provisions, imprisonment for repeated offences with 5 years of the first or subsequent offences. Earlier it was too much. And for employees, advantage is we talking about the section 4 category of the worker need not contribute to social security fund, means the category of worker need not contribute to social security fund shall borne by the government. Outreach of scheme to unorganized and the informal sector. 2. First time statutory provision for issuance of appointment letter, transparent ways of employee engagement and to be prevent exploitation. Cut-off date for salary disbursement advanced to 7th of consequent or subsequent month. Recognition of gig work is available there and more formal jobs. Then we go under the employee safety and health code, the advantage and disadvantage. First we are going to discuss about the advantage of these occupational safety and health code. Fewer laws mean better monitoring, easy compliance, one registration, one license, one return, one common authority, one all India license valid for 5 years for engaging contract labor. Otherwise earlier it was engaging for the every year, it has to change. Then the legal provisions strengthened to make employee abide safety norms does not apply to apprentices. Web-based inspection for easy and smooth process, inspector and facilitator to perform the role of guiding the employee to comply with the code. Challenges: safety norm proposed would increase the directly and overhead cost in MSME sector. Additional cost for strict adherence to safety norms, then higher rate of penalties for violation in case of death of employee, punishable with imprisonment up to 2 years. Civil court barred from hearing matter under the code. What FICI can do? FICI means the frontline kicking of the organization can do in these cases. So we have given the name of the FICI there to make representation regarding removal of the provision related to filling of the complaint directly by the employee or union, section 52 of the Code of Wage. Simplification of the definition of wage under the labor code has been done. Then removal of the threshold limit of 300 for prior permission for layoff, retrenchment and closure. Earlier it is 100, it has been become now 300. To ensure that the state government to review the existing labor law, Shop and Establishment Act, Labor Welfare Fund, etc. and Industrial Establishment, National and Festival Holiday Act to be harmony with the labor code. To make representation to allow women employee worker to work on overnight, to remove consent of women employee to engage them in night shift. So this is all about in this session today, and see you in the next session in the explanation of varied with these new labor codes. Be connected with us and sign up and connect, subscribe this 4-slide HR for this advancing knowledge on the labor laws and your HR system. We are making and building here the new paradigm of the HRM in this unpleasant time.